I'm on, but there we go. All right, we'll call this meeting to order of the House Energy, Utilities, and Telecommunications Committee. As we usually do, Chairman Camp, could you lead us in a prayer, ask the Lord's blessing on our meeting and watch over us and help and guide us?
Happy to. Thank you. Let us pray. Dear Father in heaven, please bless us today to make wise decisions for the people of Georgia. We're thankful for the opportunity to serve. We're thankful for the opportunity to gather together today to hear of bills that could benefit our citizens. And please bless us in all we do. And we say this in Jesus' name. Amen.
Thank you. All right, we have Senate Bill 73. Representative Gullett, you had this in the subcommittee. You want to tell us what happened there?
We did.
What you've done with it?
Well, there's a good bit that was done to it.
You don't have to go through all the details. What you
Yeah,
did.
but it was due passed and it came out of subcommittee.
Okay. All right. And with that, Senator Tillery, if you want to make I know you presented it now twice, but if you just give us another brief overview of the bill.
Thank you, Mr. Chairman. First, let me tell you thank you for allowing me to present twice, and also thank you for coming back. I apologize to the members of the committee. We had a health emergency at the Senate Budget Office at your last committee meeting, and that's why I wasn't here. So I tried to get here early this morning to try to make up for that. But thank you, Mr. Chairman, for holding a new meeting. Senate Bill 73 is a telemarketing bill. It's aimed at telemarketing. It allows, if someone were to violate the Georgia Do Not Call list by calling someone whose number is on that list more than one time in a 12-month period, that a claim could be brought against them. What the bill originally started as was a $1,000 penalty. Your subcommittee amended it to make it to be a $2,000 penalty. I bring that up because some of the members called me this weekend and asked and wanted to talk through the bill, and I told one of them specifically, who's not present, that the penalty was only $1,000. I missed that amendment, and I just want to be clear to the members. I don't want to hide the ball for you. Y'all did amend it up to $2,000, which is perfectly fine with me too. It also allows those claims to be brought as a class action. The point is, and it also allows for third-party liability. And what that means is that we saw some instances where folks were using other telemarketing companies, sometimes not located in the United States, to make calls on behalf of Georgia or United States companies. So that when citizens would go to enforce their rights under the Georgia or the Federal Do Not Call Act, they could not do so because you can't bring that foreign jurisdiction into court. This bill's really simple. It's aimed at providing a little bit more peace at people's dinner tables and on their phone lines. Some questions that you asked that I may have not known the answer to at the time was, what could you add a business line? The answer is no. The Federal and Georgia Do Not Call lists do not recognize business lines. I was also asked whether or not there were exemptions, and yes, the federal law and the Georgia Do Not Call list do recognize several exemptions to the 4 calls that can still be made. Those include calls from charities or religious organizations, calls from companies which you have a current or prior business relationship, and the federal law sees that as 18 months. Companies you've given prior express permission to, and polling companies, educational institutions, or other organizations whose purpose is not to solicit the consumer, but to provide information. So thank you so much again for allowing me to present this bill, and would ask you favorably report out of committee.
All right, thank you, Senator. Would you take questions if there were any?
Yes, sir.
Okay, I don't see any. Okay. Yeah, you're recognized.
Thank you, Mr. Chairman. Senator, good morning.
Hey.
If there is a question of law about a case that is brought, does the judge decide that, or the trier of fact decide the question of law of the jury?
Question of law would be decided, questions of law are always going to be decided by a judge.
Is there I thought there was a place in the bill when I originally read it where questions of law were decided by a trier of fact. Is that language in here now?
There's language about trier of fact, but I don't think it puts questions of law to them.
Where is it in the bill? 170.
172 has some of that language.
You know where it is, Senator?
171.
171. It shall be a defense for the consideration by the trier of fact if the defendant has, with respect to the persons or entity that made the telephone solicitations. Is
Yes,
that
sir.
normally a question we let the jury decide, or is that normally a question the judge decides?
Well, I think it was entered in, this came from one of the Georgia companies who originally was talking about this bill, and they asked for some additional language. And what they wanted to be able to inject into the bill is if they did have policies that tried to make sure the Georgia Do Not Call Act was enforced, that they could bring those as a mitigating defense at trial. So they could basically present, hey, look, we were trying to do the right thing. We shouldn't be fined for this.
Yeah, but that's
They-
normally a question the judge decides, and you've got this drawn up where it goes straight to the jury, because the jury will be the trier of fact in a jury case, correct?
I don't think that's necessarily a case that a decision that the judge would decide. I think when you're having a jury, I think that people on the jury get to decide whether or not it was mitigating, just like they would self-defense or anything else.
The other thing I wanted to ask you about is you've stricken the word knowingly all throughout the bill.
Yes, sir.
And that required a company who got sued that if they knew someone was calling on their behalf, that then they were obviously liable if all the other things fell into place. But now, the difference in your bill and the current law is that if a company didn't know someone was doing something wrong, they'd still be liable for their actions, correct?
It does. The third-party liability exists, and it's not if they didn't know. What we saw, what was quite blatant, in fact, was that you had companies say, I didn't make the call to you. And so if they didn't make the call, then they couldn't be held responsible under the Georgia Do Not Call Act. So the reason that we had to strike knowingly is because if you've outsourced that call to others, the only way we can put third-party liability would, I think that lost me. Okay. The only way we could strike third-party liability would be to strike the knowingly. There is still a way that companies can avoid liability on this. They simply cannot make calls to folks who are on the do not call list.
The problem is that they hire third parties, and those third parties make those calls. And, name your company, Coke, they've hired someone to make telemarketing calls for them. That company's somewhere else, maybe beside the U.S., India.
Right.
And Coke tells them don't use the do not call list, but they do anyway. Now we're going to hold Coke responsible for what the company in India did, correct?
Well, yes, which is why the language in line 171 is so important, because what Coke was asking for, and it wasn't Coke in this instance.
Oh yeah,
but it was a
I
Georgia
just threw that
company.
out there,
Yeah, it wasn't Coke.
It says Waffle House.
We could say it's Waffle House. I don't think the company would mind if we said who it was. But it was a Georgia company. I'll still protect them for innocence purposes. But by what they asked for is they said, hey, look, we get it. We've contracted with a company. Can we bring in the fact that we've also put procedures in place to make sure that that company abides by the Georgia Do Not Call list? And I said, yes, that's very, very fair. And they're like, cool. I said, now we do need to make sure that your procedures aren't you wrote them a letter or sent them a text and said, hey, make sure you follow the Georgia Do Not Call list. Because that, if you make that a strict liability defense, I guess, then that's going to allow them to abscond from all liability by sending a simple text. Or maybe they sent it as a smoke signal or carried it by carrier pigeon. That's not something we want. We want to make sure that their procedures in place are actually adequate to stop the calls, which is why we did it as a trier of fact.
So would you be opposed on line 71 if we make that the judge by simply removing the words the trier of fact if the
I would prefer we not. I mean, I understand I'm in a House committee and the House can do what they want. I think this was the same amendment that came up in subcommittee and failed. I know it could still pass in committee. I'd prefer we not, because I'm afraid that by striking the knowingly and then allowing this, that what we've allowed is that we're no longer taking into consideration what type of mitigating steps a company has taken to make sure the other company follows the Georgia Do Not Call list. We're now at a position where we're just saying, hey, if you write in your contract with them, make sure you follow the Georgia Do Not Call list, then the originating company is absconded from liability, which puts us right back where we are now.
I appreciate that, but I didn't mention striking the knowingly. I just mentioned striking the words in line 71, the trier of fact, because it's my understanding in the law we normally allow judges to make those decisions. We've already stricken knowingly. So
that's already done. The question is if you strike.
I wasn't asking to put it back in, that's what I was saying. I wasn't asking to put knowingly
Right.
back in.
I do think, though, that we should allow those companies, I think we should leave it the way it is so that those companies can get into the hearing the mitigating steps they've taken.
Because if they could go before the judge before the case began, it'd be a lot cheaper to resolve it.
Well, they could, first of all, I think with damages being so certain, you're probably going to see mainly bench trials anyway.
Thank you, Mr. Chairman.
Thank you. Chairman Martin, I think, has a question.
For those non-lawyers amongst us.
Yes, sir.
You Representative Fleming, go back. Serious question here. You got a bit to it in your testimony. So if I'm company, the Georgia company you mentioned to, and I'm going to hire a telemarketer to do this for me. What keeps? Well, let me ask you this question: would it, if I put in that contract with that company that you indemnify me against any claims from the do not call list, you shouldn't do it, don't do this, you should never do this, all that stuff, and then you indemnify me, is that a defense?
So this bill doesn't.
Or is that, I guess the question is, I'm telling you not to do it, and I'm telling you, you indemnify me, so if they come after me, and you've indemnified me from a legal perspective, if somebody finds something, that was broken, and they sue me, the Georgia company, or Company X, whatever one do it, and I have that indemnification in my contract with the telemarketer, what's going to happen at the end of the day if somebody said there was something that was a violation and company telemarketer is offshore? What's going to happen to the damages? I honestly don't know.
So this bill does not contemplate or change anything related to indemnification. But what I would imagine would happen would be this. You're going to have a company that's overseas, and the telemarketer, the company asking for the telemarketing call in the first place, we'll call them Company X like you did.
Right.
They're going to find out that they now are in the legal position that the citizen of Georgia used to be in, of, hey, look, you violated a contract with me, or Georgia do not call this contract, so I'm going to go after you, but now you're overseas, and I'm going to have an extremely hard time getting to you. What I think it's going to do is it's going to cause Georgia companies to be a whole lot more careful about the procedures they take when they're bringing on telemarketing companies in the first place, which is exactly what we want. We want folks who are going to be reputable, who are going to study the Georgia do not call list.
And to follow up on that, the difference there is Company X and the telemarketing company are entering into a contract. They get a chance to hammer all that out as they go into a contract. Consumer and Company X or the telemarketer don't have that opportunity to go into, which is what you're trying to fix. So I think what I heard you say there is if I'm Company X and I'm hiring this, I have the ability when I go to contract to take care of myself. Right? I mean, if I don't like the contract that I have, I don't have to sign it with that particular outfit that's going to do telemarketing. I can find one that will abide by. I mean, I'm a small business guy. I mean, my experience is big companies, if they find a small company they don't like the interested in the country, they'll find another one that will too.
Right.
So
I think you're right, and I think that language on line 71 preserves the ability of the company to be able to bring in that information for mitigation purposes at trial, or before the judge if it's a bench trial.
That's it for me.
All right. Somebody over here. Do you have a question? Representative Thomas recognized.
Thank you, and I appreciate it. I want to give you credit. You called me 3 times when you heard I was concerned about your bill. So we actually talked last night at almost 9:30. So thanks for being as accessible and available as you've been on
Thank
this.
Did you get my text before the hearing?
No, I did not.
I mentioned it
should
to the
take
full committee,
What's
and
that?
you brought up last night the penalty provision.
Yeah.
And I was wrong, and I need to correct that with you
Okay.
before you vote. If it changes your vote, I understand. But the penalty provision was amended in subcommittee to 2,000, and I told you it was 2,000 for the Attorney General and 1,000 for for a civil action, which is incorrect. It is 2,000 for both. It was changed by Representative Montahan, or
Okay.
proposed and passed with 1 no vote.
So my actual question has to do a little bit with the concern that I had with small business a lot of times you'll see people that use their personal cell phone also as a business cell phone. And I was thinking about that a little bit, just because I think the intention of the bill is good. I think you're trying to go after the right people. I just always worry that we're going to spread the net so wide we're going to catch people inadvertently. Would you be open to something that would possibly make it where if the cellular device is also used as a business device, like possibly give a little bit more leniency there? I mean, is that?
Well,
I'm not a lawyer, so you can.
Yeah,
draw
I'm not. I
legalese.
don't know that I understand what you're trying to fix.
So a lot of times, for example, I will call a client, or I will get a cell phone number from a friend. Okay, and that cell phone number is used as a business number. Like on their cards, they will use their personal number as their business number. And I'm concerned that my business, sometimes because we do cold calls, if we have a cold call to one of these people that aren't on the Georgia list, but they're using it as a business phone, not a personal phone, that they're also going to get caught into this.
Gotcha.
And I didn't know if there's a lot of smarter people in here than me, Barry Fleming.
You may be correct. So let me walk you through. I told you last night that I didn't know how to fix. So business lines are not allowed to be put on the Georgia Do Not Call list. So I don't know if that fixes your concern from the beginning. But if it is a business number, it is not allowed to be registered as on the Do Not Call list to begin with.
Mine's more specific to the personal numbers, the personal cell phones that are used for business purposes. Yeah, it's still considered a personal number, but a lot of times it's used as a business number, and it's like this one little catch-all, little caveat that I've just got concerns about it. So, and if there's not a fix for it, then there's just not a fix for it. But it was the only thing that concerned me. Go ahead,
Just
Chuck.
to interject, I mean, you don't have, if you choose not to put that number on a do not call list, this bill doesn't impact you. So isn't it true, if I were using my phone and it's personal number, not a business number, but I was using it for hybrid, that I just wouldn't put it on the do not call list. And therefore this bill wouldn't be impactful to that number. Isn't that true?
If it's not on the Do Not Call list and business numbers can't be, then I think
But
you'd
if
be okay.
he was using his personal number for business purposes, so people calling him back and forth, and he didn't want them to get called on that, he just wouldn't register that number on the do not call list.
So, to that note, I wound up getting phone calls from August all the way straight through to the end of November from healthcare providers trying to sell me healthcare insurance, but it is a business line. If you use I use my business line number as my personal number as well. So, in that case, I don't want to put my number on the do not call list because I don't want to. But maybe I should probably do it now. I'm talking through it. But I'm just saying there's just one small thing, but I'm good with the question. Thank you.
Okay, good. Chairman Martin, did you have another question?
No, sir. No, I was
Okay.
left over from last time.
I think Representative Okoye, did you have a question?
I really do, and that's going back to what Representative Thomas was asking.
Now, if it's the same question, we don't need to have it again.
No, it's the other side of it,
Okay?
which is, of course, I do use my personal line for my business too. But when I call, because we do cold calls to generate work contract. So when I call a possible client, would that be considered a nuisance call or what?
It depends. So if their number was not on the Do Not Call list, you're fine. If you had a previous business relationship with them, you're fine. If they are let's see here. I'm going to go through the rest of the statute. If they've given you their number, in other words, you put it out online and said, "Hey, I'm selling gutters, and if you want to view my website, enter your cell phone number or email address, and now you can view my website. Then you can do that. So if you've put it out and then they've given you that number, or you had a previous business relationship, in other words, you worked with them previously, then it is not considered a solicitation. If you've not done one of those things, then yes, sir, it is.
Can I answer your question?
I guess it did, but I'm so confused now. All right, thank you.
Yeah.
Well, I don't want you to be confused. I mean, do you want to try to clarify your?
Yeah, I mean, I can take it a little further. I'm into engineering business, and many times my calls are to the state agencies.
Okay, I can stop you there and tell you you're going to be absolutely fine because they're businesses and you'd be just fine.
Okay,
You
then
can't
I
call
have-
individuals.
I have a second business, which is a private home care provider business.
Yes, sir.
You can call people based on leads to generate clients for a business.
Okay.
Now, they may not know who I am, but because I have that lead, sometimes it could come from the Department of Community Health. How do you classify that?
Yeah. If the information, suppose someone needed home care services, so they've submitted their information to the Department of Community Health, and the Department of Community Health has now taken and given you that information as a provider in that area, you're going to be fine because that individual gave their information first for the purpose of that solicitation. So you're covered in that instance. What you would not be covered as is if you tried to go pull the hospital records, which you couldn't do anyway because of HIPAA, for everybody who had fallen and broken their hip, and then wanted to call them and say, hey, you've fallen and broken your hip. I want to make sure I can bring you a wheelchair. Well, now you're completely cold calling them. They've not turned in any information, asked for any information, or asked for any services. That would be the call that is prohibited.
Okay, thank you.
All right, good. I don't see any more questions. I hope everybody's had an opportunity to read through the substitute. This was going through Representative Gullett's subcommittee the other day. I think they spent at least an hour working on this. But, in full committee, I don't take any testimony in full committee. As opposed to some committees, I do want further discussion and an opportunity to perfect the bill. That's just the way I think, for me, that it should be done because everybody wasn't in everybody's not on Representative Gullett's subcommittee. I think we have a question. Who is that? Representative Kelly.
Not a question, Mr. Chairman. I just wanted to echo what you said. I appreciate the work that Chairman Gullett's committee did, and I understand. This is a problem. As I've sat here in committee, my phone's, I've received multiple spam calls just as I was sitting here, and this is a problem. And I think previously we've had a scalpel approach, and it hasn't worked. And Chairman Tillery's brought us a little more of a butcher knife approach because the scalpel hasn't worked. And I hope that this committee will have the same approach that Chairman Gullett's committee did. And let's make sure let's put the big knife on the table here. And so, Mr. Chairman, if it's appropriate, I'd like to make a motion to pass.
Second.
Okay, it is appropriate. If you'll make that motion. Make the motion.
Motion to pass.
There's a second and a second. Any discussion on this bill? Senate Bill 73, LC 36557 2S. Any discussion? Yes, sir.
Mr. Chairman,
Recognized.
there are two places in the bill where I think we depart from the way we normally handle things in the law. And I mentioned them earlier. It's on line 171 where it says a defense for this action shall be for consideration by the trier of fact. It appropriately tells you that if you didn't do this, then you can plead to the court, and you can the court can decide that you don't need to be here. Problem is that the words for consideration by the trier of fact on line 171 and 175 require you to impanel a jury if you're in a jury trial. And believe it or not, the law tries to dispose of matters as quickly and as reasonable as possible, even though it doesn't seem that way quite often. And if you have to impanel a jury to even ask the question, do I belong to be here and use this defense, then you've moved past the ability for the judge to resolve this in something we refer to as summary judgment, which is the typical way I believe you would resolve matters of, hey, I have a defense it allows me to do, let me tell you what it is, I don't belong to be here. So it makes it much more expensive to get to a possible resolution and use that defense. So the question I asked the chairman, Tillery, was would he consider striking on line 171 the words for consideration by the trier of fact if the defendant has, and then on line 175 it would be the words for consideration by the trier of fact. What that does is it leaves the defense there for the person to plead to the court, hey, I don't belong here because this is a defense that you've given me, and it allows the judge to decide that well before you ever get to a jury trial. And that's the way we normally handle things in the law, and this is a deviation from it. So my request, Mr. Chairman, would be to make an amendment to strike those two words, those two phrases I mentioned on line 171 and 175.
Okay, well, you're recognized to make that motion if you care.
It would be striking on line 171, beginning with the word for consideration by the trier of fact if the defendant has, and then the same similar phrase on line 175, for consideration by the trier of fact.
Okay, the gentleman's made a motion. Senator Tillery, do you object to that?
I would, Mr. Chairman. The two defenses that were added were brought by Georgia companies and then by the Cable Association. I added those in, working in good faith with them, but we want them to be as mitigating circumstances, not as direct bars. The reason being is the issue we discussed earlier. If someone has a defense and they say, hey, I told them not to call people on the do not call list, we don't think that's nearly as effective, or what we want. We want instead them to say, listen, here are all the things we did to keep you off to make sure the do not call list was honored. We had these processes in place. We checked back with them every 6 months to see. We saw how many times they violated. When they did, we made them put steps in to fix it. That's what we want. And that's why what the company does is just as important as what they didn't do. So to get that in and to not have it be a straight bar, I think you have to allow it to go to the trier of the fact for mitigating, not for a question by law.
May I ask a question, Mr. Chairman?
Yes, you may.
Mr. Chairman Tiller, you and I don't disagree on anything you said. All my amendment does, it allows the judge to decide that before you get to the stage of a jury trial. Don't you agree?
No, sir, I don't.
How so?
I think defense would keep it from ever getting to the point of the other side being able to present their facts of what actions happened by the company.
They would present to the judge, would they not?
No, the defense would come in and they'd say, hey, listen, we have an agreement. We told them not to call the people on the do not call list, and therefore we should be allowed to go. The other side is then going to say they violated this 2.5 million times, or as we heard the U.S. Chamber present last time, I think it was something to the tune of they had called it would have been the equivalent of calling every Georgian 18.8 times. And they said, oh, this was only 2% of our or 0.2% of our cases. That stuff needs to come in.
And in your fact scenario, the judge would decide that question, would he not, if this amendment were in?
I think the judge doesn't get to balance out the egregious nature of the other side. He then says, look, they have a defense. They said this. The defense stands. I don't think it gets balanced.
Okay, we have a motion for an amendment by Representative Fleming. We have a discussion. We have not had a discussion. We have not had a second yet, but I am going to ask, I recognize Representative Kelly. I believe you had something you wanted to add to it at this point.
Chairman Tillery, wouldn't you agree that in the scenario that you just proposed, this is a extremely fact-based scenario? It's going to have a lot of factual variations to it.
Yes, sir.
And generally, isn't it true that summary judgment is simply decisions of law, not fact?
Correct. And if you had a defense, then the decision's made. It's not ever mitigated.
And generally, don't we let inquiries that revolve around different factual scenarios, aren't those always reserved, or pretty much always reserved in law, to be decided by the jury and not the judge versus questions of law?
Well, they could be decided by the judge too, and that's what I think is going to happen here mostly, because I think you're going to see bench trials.
Unless
the
the plaintiff asks for a jury trial or the defense asks for the jury trial,
Right.
they're resolved by the judge. But if we get a jury trial, don't questions of fact usually get resolved by the jury unless
If there's a jury trial.
if there's a jury trial. And that's the difference in what we're debating here, a question of law versus a question of fact, and isn't most likely in the scenarios you proposed here. These are questions of fact, not questions of law.
That is true.
Thank you, Mr. Chairman.
All right, we have a motion by Representative Fleming. Do we have that? Does he need to restate that? Sean Murray, does he need to restate his motion?
In terms of striking, I did have one question on your first one. Are you striking reason past prior fact on line 171?
However, show DA's defense with respect to the person you think I should instruct the word family.
That was my question, if you should be, if the defendant has.
Okay, I see what you mean. In other words, you say stop for consideration by the trier of fact. I was thinking the same. I agree with legislative.
Okay. So we have a motion for an amendment. The author objects, and I know that the committee will take it all in consideration for their vote. Is there a second? There is no second, so the motion fails. Any further discussion? I think we've had on the main motion, we've had a motion and a second. Did you have further discussion? Okay.
I'd actually, because I still have this concern about small business getting caught up, and then the requirements that they're now going to have to go check the Georgia Do Not Call list, which admittedly nobody's been able to really mitigate that part. So since we can't get rid of it, I'd like to make a motion to take the fine back down the way it originally was to $1,000, because if a small business gets caught on accident, I think 2,000 is a little steep.
All right, we have you
Would
haven't
you
been recognized
accept that
for the
as a
motion.
friendly
but-
amendment?
I would, and I would ask, if you don't mind, Representative Thomas, to only do that on line 159. That's the civil cause of action. The Attorney General's has always been 2,000.
Okay.
And it was 2,000 actually in the civil cause too. But if you would only do that on line 159, I'd consider
Okay.
that friendly.
I'd agree to that.
Okay. Do we have that, Sean Murray? Okay.
I'll second that motion.
Okay, so I recognize him for his motion. We have a second. Any discussion? All in favor of Representative Thomas's motion indicate by saying aye. Aye. Any opposed by no? That motion for the amendment passes. And did you have something? No. Somebody
I was
did.
just gonna say, I came to an EUT meeting and the Judiciary Committee broke out.
Yeah, okay. Representative Meeks, you have a question? Did you have something?
Yes, sir.
Okay, you're recognized.
Thank you, Mr. Chairman. For members of the full committee, just want to point out that the bill was amended in subcommittee by a tie vote, with the chairman making the tie-breaking decision to add Section 1, which is HB 92, to the original Senate Bill 73. And with that, Mr. Chairman, I would move to strike Section 1 of the bill to take it back to the original Senate Bill 73 as amended.
All right, you have not been recognized yet. I'll ask the author of the bill. Do you object to that?
I'm before a House committee, and the House can make any changes they wish.
Okay, the author does not object. You recognize, state your motion.
Mr. Chairman, I'd move to strike Section 1 from the current amended version of the bill.
All right, there's a motion. Do we have a second?
Chairman, I would have leeway to make the changes.
I'm sorry?
Would I have leeway to make the changes in the title
Yes. You have my permission. Okay, we have a motion. Do we have a second?
I'll second for purpose of discussion, Mr. Chairman.
Okay, we have a second. Any discussion? I'm removing to section 1.
I just have a question.
Okay. Go ahead.
My concern with section 1 being in the bill is, and maybe legislative council can help guide me here, is whether putting both these together would violate the multi-subject provision that we have in terms of as law in Georgia, and whether combining both of these could kill the whole bill. And maybe legislative council can shed light on that for me, because I greatly want the sections 2 through 2 pass, and I, and generally don't have a problem with section 1, but section 2 through the rest of the bill, something I think Georgians are crying out for, and I don't want us to do anything. I think this will end up being something that gets litigated, and I don't want us to do anything to put the underlying bill in jeopardy, knowing that we do have section 1 alive in another bill. And so that's my question for legislative council. Does that violate the
Yes.
multi-subject rule?
So when looking at that, our office usually looks at like a nexus, and I think there's an attempt online too to tie the nexus to telephone and electric services. But the two measures, one of them has to do with investments in electric membership corporations, and the other one has to do with telephone solicitations. So I think the opinion of our office would be that it is probably more likely than not that there would be a successful challenge on the issue of
Okay.
That's-
ultimately.
That's my concern, Mr. Chairman.
Okay.
I have great appreciation what the chairman's trying to do with the underlying bill, and I just have concerns about combining them both.
Okay, thank you. Thank you, Representative Kelly. Thank you, Council. That was added in subcommittee. Yeah, you may. Just 1 second. I'm trying to mull this over a little bit. We have a motion on the amendment and a second, as I recall, and we are in discussion. Yes, who is that? Representative Fleming?
I remember this section 1 HB 92, and I was trying to figure out, isn't this Houston Gaines bill that we passed out of here? Okay, thank you.
Okay. Well, we have a motion and a second, and that will have to proceed. Representative Carson.
Thank you, Mr. Chairman. I just want to point out that in regard to this, this is HB 92 that's passed this committee. Is passed this bill in this form at 60% per Chairman Martin's guidance and wisdom has passed several times. This has to do with basically allowing electrical membership corporations to have a larger percentage of an investment. I would ask for the committee's indulgence here. We're still talking until in Title 46. It's my understanding, Legislative Council, correct me if I'm wrong, but we still do have a severability clause such that, to Representative Kelly's point, if one part of the bill was deemed invalid or what have you, the others would stand, correct?
That is typically true. However, with the multiple subject matter issue, it is a constitutional issue, and it would render both parts of the bill invalid.
Okay. We do. I think. Did you have a question, Vice Chairman? No. Okay. Representative Gullett. Okay. Well, we have a motion and a second on the proposal, and that is before the committee. Regardless of what I think or opinion I have, it doesn't make any difference at this point. It's up to the committee. No further discussion on this amendment. All in favor of the amendment by Representative Meeks indicate by saying aye. Aye. All opposed by saying no. Okay, the amendment does pass, and Section 1 has been taken off. Any further discussion on the main bill here, Senate Bill 73? And we already have. It's already been a motion and a second. So all in favor of Senate Bill 73, LC 365572S, indicate by saying aye.
As amended.
Any opposed by no?
As
Okay,
amended.
this, as amended. The measure passes. Thank you, Senator Tillery, for your hard work on the bill. Appreciate it.
Thank you.
Thank you. We do have another measure, if you could hold on with us just for a minute now. Did you want to proceed with yours? Okay. We have a resolution by Representative Mandisha Thomas. If you hold on with us just for a few minutes here. She had presented this in full committee. We gave it to subcommittee. I brought it back to full committee since we're late in the session. She has so some of you have heard this, so maybe all of you, but anyway, she's got a sub. It's actually a committee sub that she's going to present. It's a much more concise, narrowed down, to the point. And if you'd like to make just a brief presentation of what you want to do with your subcommittee.
Thank you, Chairman. State Representative Mandisha A. Thomas from the 65th District, here to present H.R. 10, LC number 550066S. This was presented last month in Chairman Anderson's subcommittee. A full dissertation was done on that bill, and we have decided, just like the chairman said, to narrow it down and define it a little bit better. This study is the public water system serving disadvantaged communities, and there are multiple packets or pockets of money on our federal infrastructure bill that we want to look at. We want to be able to review those resources and put them in a more tangible format for the state, county, and municipalities to easily ascertain. The second thing we want to do in the study will be also to identify disadvantaged communities across the state and review of their water infrastructure systems. So it's very simple. We just want to pull out the resources and make sure that the counties, the municipalities, and the state have tangible access to these resources. And we're looking at the water infrastructure systems that a lot of municipalities across the state of Georgia are having an issue with.
Any questions of the author? I see some lights, but I'm not sure who really has a question, who doesn't. Do you have a question?
I do not. That's what
Okay.
the chairman makes.
Vice Chairman Barton? Okay. Representative Kelly, do you have a question?
Yes, sir, Mr. Chairman.
Okay.
It was kind of left over from the last bill, but since it hung on, let me ask this: Do we have in code, and maybe this question for Legislative Council, in code, do we have a definition of what a disadvantaged community would be? Is that defined anywhere in code?
Chair?
And if not, maybe I'll ask
Yeah.
the bill author what.
The chair doesn't know, but I don't know if anybody else does or
Is
not.
that defined somewhere?
Looking it up.
It's a good question.
I just don't know who exactly we're trying to address.
Okay. Yeah. We should be finished here any time. Okay, Alan. Show them where you're looking.
I'm looking it up, but I don't think that the committee would be bound to that definition regardless of what it is, and I think it would be up to the committee, once appointed, to define the parameters of what it considered a disadvantaged community.
All right.
Any other questions? Any other questions? Representative Thomas, other Thomas.
Thomas 2, number 2.
Thomas too.
So I actually had a town hall meeting on Thursday back home in Cherokee County, which is definitely not I don't think, considered a disadvantaged community. And one of the things that came up was drinking water, ironically, and some concerns about some EPA reports. So to me, I wouldn't limit it. I think we should be concerned about all Georgia's water, not any specific subgroup of Georgians. So at the proper time, I'd like to make a motion to make an amendment, but that's more of a question than a statement than anything else.
All right. Any other questions? Any other questions of the author? Now, the chair is going to say, I've worked with Representative Van Bishop Thomas on this and tried to narrow it down, and but no, I'm not either for or against it. I'm just saying I've worked with her and on this sub, and with that, I mean, it'll be up to the committee what is done with it. So with that, Representative Thomas, what number are you at? 8. Well, no, we're not ready for that. We're not.
Yeah,
ready for
we're
that.
good.
We're not ready for that. Is there what is the will of the committee?
Move to pass.
Okay, we have a motion, do pass, and second. Any discussion?
Proper time, I'd like to amend line 8, removing disadvantage and striking disadvantage and changing, say, Georgian or Georgia communities.
Okay. And
And line 1 as well.
And you want to do that? Why? Tell us again.
Like I said, so I was at a town hall meeting, and one of the concerns that came up was some EPA reports up in Cherokee County about some questions and some of the issues with the water up there. And because of that, I think that we shouldn't solely focus on any one group. I think this is a statewide issue and should be looked at statewide, and that's the reason I wanted to make the change.
All right, you're not recognized yet. I would ask you, just ask the question, I guess. Wouldn't it be true with the study committee?
Yeah.
With the study committee, they could focus this ever how they wanted to. If they wanted to focus on what they consider to be disadvantaged or not, that would be up to the study committee.
And this would only broaden, and obviously it'd be at the will of the study committee. But however, I just want to repeat this one more time. I'd like to strike the word disadvantaged and change it to Georgia, specifically line 1, line 4, and line 8.
Okay.
Yeah.
Striking disadvantage and replacing it with Georgia.
Representative Thomas, do you have any objection to that change?
Thank you, Representative Thomas, too. You know, EPA defines what a disadvantaged community is under our Safe Water Drinking Act, and disadvantaged communities aren't just subject to one geographical location of the state of Georgia. It's all across the state of Georgia in urban, rural, and suburban areas. So I think it takes an account for the entire state.
Well, to the lady, I would just, from the chair, I would say that striking that, and it's going to be up to the committee what to do, and you're a member of the committee, but I would say striking that doesn't change anything. It's still a study committee, and the study committee can ask questions and learn about this issue to whatever extent that they decide to do once the study committee is established. That's just the way they work. So I'm not advocating for or against the amendment, but I just want to make sure people understand that. Yes, sir.
After speaking with legislative counsel, I think we might have some compromise that might work for everybody here.
Okay.
So we're going to start over. So the amendment would be as such. Line 1, getting rid of the word disadvantaged. Line 2, adding in Georgia after communities. We'll keep line 4, which keeps the term disadvantaged in the bill or the resolution.
Are we can we interject just 1 second? Are we reading off LC 550028S? Because you said line 1, take out disadvantage.
I've got 0066S.
66S. Okay, thank you.
Restate.
Okay, so take out.
So I'm going to start over from the beginning.
Restate it.
All right, line 1, striking disadvantaged. Line 2, after the word communities, we add the language in Georgia.
Okay.
We'll keep line 4 as written. Line 8, we'll do disadvantage. Once again, strike out disadvantaged,
okay.
And then after communities, add in Georgia.
Okay.
And that, I think.
All right. Okay, so we have a motion and a second. Any further discussion on this amendment? I don't know. I see lights, but I'm not sure if anybody really. Yes, sir.
Thank you, Mr. Chair. Representative Thomas, does that impact your intent for this bill? Does that amendment impact your intent?
I think from what Ledge Council and the chairman has said that it would be a great compromise.
Is your question?
Does it impact your intent?
No.
Okay, thanks.
Okay. All right. Any further discussion? Seeing none, all in favor of, we have a motion and a second. All in favor of Representative Thomas's amendment, indicate by saying aye. Aye. Any opposed by saying no. The amendment passes. Any further discussion on the resolution? I don't think so. I don't see any. All in favor to the committee substitute to House Resolution 10, indicate by saying aye. Aye. Any opposed by saying no. The resolution, the committee substitute passes. And congratulations, Representative Thomas.
Thank you, Chairman.
moved
Thank you,
this
members
on.
of the body.
Well, you're very welcome. Make sure that you take care of the paperwork, which I assume you're familiar with. You got some paperwork you have to take care of with the Rules Committee. It's a form. I mean, there's the.
Yes, sir.
Be sure to do that, and thank you. And unless there's something from the committee, we are adjourned.